We now move on to the next item of business, which is a debate on motion 19275 in the name of Shirley-Ann Somerville on motion on legislative consent public authorities fraud, error and recovery bill UK legislation. I'd be grateful if members who wish to speak were to press their request to speak buttons, and I call on the Cabinet Secretary to speak to and move the motion.
Thank you, Presiding Officer, and I move the motion in my name. This is an opportunity to speak to the motion on the legislative consent in my name in reference to the Public Authorities Fraud, Error and Recovery Bill 2025. When I spoke to the previous consent motion in my name, I was clear that, while I support efforts to reduce fraud and error within public finances, this cannot be done at the expense of treating people with fairness, dignity and respect. Today's motion relates to two particular areas within the bill for which I am happy to recommend legislative consent. I will also cover the overpayment provisions for which I previously said I would not recommend legislative consent and which have subsequently been amended by the UK Government to ensure they do not apply to any devolved benefits, including those administered under agency agreement. Firstly, in regard to non-benefit payments, the UK Government is proposing to use recovery and enforcement powers under the Social Security Administration Act 1992 to recover payments that they make beyond social security. For example, they may seek to recover grants they pay out using this legislation. I am content to recommend consent because, although the definition of non-payment benefit may be broad enough to encompass recovery of devolved payments, the UK Government have confirmed in writing that they have no intention to do so now or in the future, rendering any potential impacts on devolved matters theoretical only. Furthermore, future devolved payments that could be administered by the Secretary of State and may fall within the scope of these powers could themselves require primary legislation and subsequently Scottish parliamentary consent, which will ensure due parliamentary process before any introduction. In the bill as introduced, authorised DWP staff would have been able to seize evidence relating to the commission of a DWP offence, i.e. where it relates to a social security fraud. The provisions have been amended and will allow authorised DWP staff to preserve evidence found relating to any crime should they encounter it when entering or searching premises. There is precedent for this approach. Immigration legislation allows immigration officers to seize evidence of non-immigration offences in order to ensure evidence is not lost and can be passed to appropriate law enforcement authorities. There is therefore nothing in these provisions that, in my view, conflict with the principles underpinning the devolved social security system. I now turn to overpayment recovery. These provisions do not appear within today's motion because the bill was amended by the UK Government to ensure that devolved benefits, including those paid under agency agreements, will not be subject to the new recovery powers. However, I know they will be of interest to the Chamber. I acknowledge the UK Government has a duty to manage public finances responsibly, and that is a responsibility that Scottish ministers share. However, it cannot be done at the expense of our principles and ethos. Social Security Scotland already has a range of powers available to it to recover overpayments that arise as a result of fraud and error. The agency's published error control strategy sets out that it already uses routine quality checking, data analysis and claim reviews to detect error and routinely recovers debt. Social Security Scotland's next set of annual accounts, due for publication in November, will set out that more than £9 million of overpayments were identified and corrected in the financial year 24-25 as a result of fraud or error interventions, with almost £3 million of associated estimated future losses prevented. Social Security Scotland has a long-established zero-tolerance approach to fraud, outlined in their published counter-fraud strategies, and a wide range of investigative tools at their disposal, including intelligence sharing, fraud reporting channels and the use of surveillance where appropriate, all of it designed to rightly protect the public purse. Therefore, I can reassure colleagues in the Chamber that the Fraud and Error Service, while still maturing, clearly adds considerable value in terms of protecting the public purse. However, whilst we are content with many of the measures in the UK bill, the Scottish Government does not support those provisions that would allow the DWP to deduct money directly from a person's bank account without a court order, or to suspend a driving licence. As a result, it will be necessary to adjust the working arrangements between the governments to ensure that these specific new powers do not apply to the recovery of devolved debt accrued while DWP delivered benefits on our behalf under agency agreements. I want to be clear, though, that this does not mean that the approximately £35 million of historic debt covered by those arrangements will not be recovered. Officials are now discussing with the DWP to identify the debts and the arrangements for transfer, and therefore the options to recover this debt in line with the extensive powers and the administrative arrangements already at the disposal of Social Security Scotland. Thank you, Presiding Officer.
Thank you. I now call on Bob Doris on behalf of the Social Justice and Social Security Committee.
Thank you, President Officer, and I'll be brief because it is underlying a procedural issue. The Social Justice and Social Security Committee considered a legislative consent memorandum on the Public Authorities Fraud Error Recovery Bill in June. At that time, the Scottish Government advised that they had not seen the full provisions of the bill until it was laid on the 22nd of January, and they were consequently unable to meet the normal timeframes for lodging an LCM, which is important. Despite that, there was time for the committee still to scrutinise the LCM and come to view on part of the provisions, and we were able to recommend consent on that basis. The Cabinet Secretary for Social Justice made us aware that due to ongoing engagement required to understand whether the bill and its numerous amendments will impact on Scotland, she expected there would be a requirement to lodge a supplementary LCM, which we now have before us. That LCM was lodged on Friday the 3rd of October. The committee was made aware that this meant there would be no time for it to consider the LCM at our committee, as a decision on the consent was required ahead of the final amending stage at Westminster, which is due to commence on the 15th of October. That is clearly less than satisfactory. The legislative consent process reflects a key principle underpinning devolution, which is that the UK Parliament will not normally legislate and devolve matters on changes to the boundaries of devolution without the consent of this Parliament. Parliamentary committees play a key role in scrutinising provisions to legislate on devolved matters within UK bills and coming to a view on whether or not to recommend consent. It is essential that committees are provided with sufficient time to carry out that scrutiny, irrespective of the merits of any individual LCM. I very much hope the Scottish Government will emphasise to the UK Government the importance of the scrutiny role of Scotland's parliamentary committees for considering LCMs in the future, in the hope that such occurrences do not occur again. However, in this instance, I can confirm our committee agreed that the LCM should go direct to the Chamber.
Thank you. I now call on Alexander Stewart.
Thank you, Presiding Officer. The Parliament's primary duty is to pass effective legislation, and I know members will agree that that can only be done if there is effective scrutiny right across the Chamber and through committees. The relocation of the LCM before us is an important issue about fraud prevention, and the Cabinet Secretary for Social Security and David Wallace did attend the Finance Committee back in September. Every penny of public money, Presiding Officer, lost to fraud is a penny taken from the hard-working taxpayers for Scotland's money that could be spent on our schools, on our hospitals or on our roads. The nurses, teachers and workers across Scotland deserve a Parliament that protects their contributions and unwaveringly diligence. We do not serve the Scots by cutting corners or bypassing domestic processes that include that. Regrettably, the process surrounding this consent has done that. For these reasons, the Scottish Conservatives will not support the legislative consent motion. Fraud in the public sector is not just a financial loss, it erodes public trust, Presiding Officer. When fraudsters exploit the system, they undermine the social contract that binds hard-working Scots to the services that they fund. The £36 million fraudulent benefit claim, highlighted by a Scotsman article back in August, is a stark reminder of the challenges that are faced, Presiding Officer. The Finance Committee recently sought answers from David Wallace for Social Security, appearing on the 16th of September. His testimony was essential to understanding how recovery of these funds. It was alarming to find that only 10% of funds of fraud have been recovered. That is why the Scottish Conservatives agree that the principle of recovering wrongfully claimed funds, it must be modernised and strengthened to fraud fighting the toolkit. The Public Authorities Bill did have an LCM considered.
Mr Stewart, if I am aware that members are finding it difficult to follow, and I think sometimes members underestimate how clearly their voices are carrying.
Sorry.
Mr Stewart, please continue.
Thank you. The Public Authorities Bill did have an LCM considered at committee in spring 2025, but this was only a considered limited provision within the bill, Presiding Officer. The Parliament then voted to give consent on the 25th of June 2025 on clauses 72, 75, 78, 81, 83, 87 and 98. It did not give a consent steer on the other clauses, and so committee did not scrutinise these properly, namely clauses 89, 90, 92, 94 and 95. The Scottish Government finally lodged a supplementary memorandum of consent on the 3rd of October for the remaining bits of the bill, but committee did not get the chance to scrutinise these at all. We accept in this instance that there have been issues about timescale for deliberation at Westminster and in Holyrood, and how the October recess has an impact on that, Presiding Officer. We do, however, wish to put on record that we believe that there should be the fullest scrutiny of all aspects of all legislation, and for those reasons we shall not support the LCM this evening. Thank you.
Thank you, Mr Stewart. I now call on Michael Mara.
Thank you, Presiding Officer. Scottish Labour will support this legislative consent motion tonight. It is absolutely right that the UK Government is seeking to update the welfare system and deliver value for money for taxpayers. The legislation gives the Department for Work and Pensions the ability to gather necessary information and to fully investigate fraud and error. These are sensible updates which will improve the system and bring it into the 21st century. But of course, the main reason, Presiding Officer, that this legislative consent motion is needed is because the Scottish Government is continuing agency agreements for severe disablement allowance and industrial injuries disablement benefits. Industrial injuries disablement benefit was devolved to this place nearly a decade ago, yet this SNP government has sat on its hands. 2.5 years ago, when I launched the Injury Time campaign alongside GMB and PFA Scotland, calling for repeated head injuries in football to be classified as industrial injuries, the Cabinet Secretary told me the benefit could not be transferred because the records were on paper and case transfer would take too long. Just last month, the same SNP government extended their agency agreement with the DWP until 2027, a decision that was rightly condemned by Amanda Coppell, widow of Dundee United legend Frank Coppell, who tragically lost his life to dementia. It begs the question, Presiding Officer, what on earth have they been doing for the last 2 years? If you do not start the process, there is no hope of ever finishing it. I have to say that the statement that the First Minister made yesterday, that devolution has reached its limits, is rather ridiculous when the SNP government haven't even bothered to enact the full powers at their disposal. And the Cabinet Secretary makes much of the different approach she wants to take in Scotland. Well, that different approach means reportedly having no plan to recover the £36 million in Scotland. And of course, in her speech, she's made reference to some belated moves to develop a plan. Of course, it was last month when it was revealed the SNP government has a 10% recovery rate for benefit, fraud and error. That's 9 in every £10 lost. When I asked the Cabinet Secretary in Finance Committee, she refused to say whether she thought that that was good enough. I know what I think, and I believe certainly what most Scots would agree with me. Just last month, Audit Scotland confirmed that position in their report on adult disability payment, noting there is no timescale for when Social Security Scotland can consider incorrect payments due to client error or fraud. No wonder, Presiding Officer, Scotland's finances are in such a mess when this is the approach from this incompetent, knackered SNP government.
Thank you. I now call on Lorna Slater.
The Scottish Greens have serious concerns about the Public Authority's Fraud, Error and Recovery Bill. The bill provides sweeping powers to investigate the bank accounts of those who claim social security. The DWP already has powers to tackle fraud. Concerns have been raised from disabled people's organisations, Citizens Advice Scotland, and even from the banks themselves that people's privacy rights will be further intruded upon as a result of these changes. There has been no clear justification that the currently held powers are insufficient and that further change is needed. The bill also fails to distinguish between overpayment due to error on the part of DWP or on the part of the recipient or from fraud. While some overpayments cannot reasonably be noticed by the recipient, this bill would allow unjust investigations and could see the money claimants depend upon withdrawn. It appears the DWP has not learnt its lesson from those who have been pushed into poverty by universal credit deductions. Today's LCM clauses 78 and Schedule 4 of the bill, today's LCM relates to clauses 78 and Schedule 4 of the bill, as well as clauses 90, 98 and 99 on non-benefit payments. In regard to clauses 90, 98 and 99, the memorandum notes that the UK Government has confirmed that there is no intent to use these powers in relation to devolved payments. These provisions are not intended to interact with devolved functions and would relate to the payments for which the UK Government has responsibility. But whilst the current Government may not have intent to do so, we are not comfortable simply taking the UK Government's word for it, and who knows what future UK Government may make of these powers. It could have explicitly exempted Scotland from these provisions, as it has done from other parts of the bill, but it didn't. In bringing non-benefit payment into scope, the intent appears to be to apply investigatory powers to grants as well as to social security payments. However, the definition of non-benefit payments is extremely broad, a concern which is also noted in the memorandum. For these reasons, as well as the wider concerns raised by the third sector, the Scottish Greens are suggesting that we do not grant legislative consent to this LCM.
Thank you, and I call on the Cabinet Secretary to wind up.
Thank you very much, Presiding Officer, and can I thank members for their contributions today. Can I point out that the motion that we are discussing today could not be lodged until the UK Government tabled their amendments, and that was not done until last week. I would share Parliament's frustration around the timetabling of this LCM and the fact that committee was not able to scrutinise it in the proper manner. But that is a reflection of the timetable followed by the UK Government for the timetabling of amendments, the Lord's report stage and the third reading of the bill. I do appreciate that that is frustrating for Parliament. It's also frustrating for the Government as well. I would gently point out to committee members, however, that I did make clear some time ago that I was not willing to accept some aspects of the bill, and I'm not aware that the committee invited me back for further discussions on the principles behind that stance that I took, even without an LCM being in place. Certainly.
Bob Doris.
Happy Cabinet Secretary to put on the record that the committee recommended the various provisions in the LCM to the Chamber based on you coming to the Cabinet Secretary, coming to the committee and giving your evidence, Cabinet Secretary. There's a more general point in relation to process, irrespective of the merits of the subsequent LCM, and that is that the Scottish Parliamentary Committee should have time to scrutinise it more generally.
Cabinet Secretary.
I think that the convener makes a very fair point about the time that committee does need to rightly scrutinise the legislation, Presiding Officer. Michael Mara touched on the industrial injuries benefit. Can I gently point out to him that if he thinks the Scottish Government has sat on their hands, I'm wondering what he thinks about consecutive UK governments, both Tory and Labour, who literally have not changed this for decades upon decades. Because if they had done something, then it wouldn't be sitting in a paper format archived in warehouses down south. And that's one of the difficulties and challenges we are facing. And what came out of the consultation that the Scottish Government undertook was that stakeholders wished us to do a full review of a benefit that has not been looked at for many a decade, rather than making small changes at this point. And I was happy to carry on that work, as has been reflected in the consultation recommendations. Presiding Officer, I said in my opening remarks that the Parliament has already provided Social Security Scotland with a range of powers to recover benefit overpayments. We have not chosen to include powers to make deductions directly from bank accounts or to disqualify people from driving. And I think if I could reflect on some of the evidence that came in to the UK Government as it looked on this issue, and great concerns that were raised, for example, by CPAG, who said that direct deduction orders do not come with sufficient safeguards, meaning more risk of hardship and unfairness for families. This direct deduction measure risks dragging these families into further hardship and even destitution by giving the DWP more capacity to deduct from a bank account whatever income or capital they have. I note citizens' advice across Warwickshire raised specific concerns about the impact on taking away driving licences to those in rural or semi-rural areas, seeming like unfair treatment. And that citizens' advice said that new powers allowing the DWP to directly recover debts from people's bank accounts are likely to affect people in the most vulnerable of circumstances. Presiding Officer, it's that type of stakeholder engagement that has meant that we are not supportive of the proposals that have came forward from the UK Government. But as I've said, that does not mean that payments will not be recovered. It is a matter of the how rather than the if. The members of committees will receive both correspondence from myself and David Wallace to discuss fraud and error, and we'll be happy again to refer to the further details that are in those letters in due course with committees should they wish to discuss further. Thank you, Presiding Officer.
Thank you. That concludes the debate on motion on legislative consent, Public Authorities Fraud, Error and Recovery Bill, UK legislation.